I'm Alex Berger from Berger Law in Marquette, Michigan. Today I'm going to talk about Miranda warnings, or Miranda rights. Everyone's generally familiar with these through popular culture, but it's when someone's getting arrested, the cops say, you have the right to remain silent. Anything you say can or will be used against you in a court of law, and so and so. Those are Miranda warnings. So first I'm going to explain kind of how they came into being and what they are. Then I'm going to talk about how they actually play out in the real world. And then third, I'm going to give one takeaway from what you've learned about Miranda warnings. So first of all, Miranda warnings come from a United States Supreme Court case called Arizona versus Miranda, which was tried by the United States Supreme Court in 1966. So it's an oldie but a goodie. Essentially, Ernesto Miranda was accused of kidnapping, robbery, a bunch of bad stuff, and he essentially confessed in an interrogation. The United States Supreme Court found that that confession was not admissible against him because they didn't tell him what his constitutional rights were before they interrogated him. So this Miranda rights, Miranda warning comes from both the Fifth and Sixth Amendment of the United States Constitution. The Fifth Amendment gives you the right to remain silent. The Sixth Amendment gives you the right to an attorney. So part of the important bit of the Miranda warnings is not just that you have the right to remain silent, but you have the right to talk with an attorney before you're questioned by the police. So this decision was just a landmark decision because it had to be trained to all law enforcement across the United States overnight. And basically they had to change their protocol for any sort of interrogations or questioning. They had to give these Miranda warnings. They developed written waivers of Miranda warnings. It was kind of a complete turnover or upset in the criminal justice system. But we've made it, and now they're just a part of our culture. We all know them by heart. So that's what Miranda is. That's how it came into effect. It was bound on all law enforcement. Now, what's important to realize is what it actually does. So in the United States, under criminal justice with the Constitution as it applies to criminal justice, if law enforcement makes a mistake and violates your constitutional rights, then what you get for that is you get that they can't use whatever evidence they got in violation of the Constitution against you. So in the context of Miranda, if you were supposed to be given your Miranda rights or Mirandized, then they don't give you the Miranda warnings, any statements you say in response can't be used against you. So this is one of the first misconceptions I get from clients talking with them a lot is that the cops didn't read me my Miranda warnings. Doesn't that mean that the case can get dismissed? And the answer is no. First of all, they don't always have to read them. And secondly, it only excludes statements that were made after the Miranda warnings should have been given. So Miranda warnings, if the police were supposed to give them and did not give them, the result is that any statements made are not admissible in court. They cannot be used against you. So that's really the outcome. If the police make a mistake and don't give the warnings when they're supposed to, that means that any statements you give can't be used against you. Now, the bigger question is, when are Miranda warnings needed under the current law of the state of Michigan and the United States? And basically, this is pretty well fleshed out. There are two things that are required in order for Miranda to be needed. First, it has to be a custodial situation. And second, it has to be an interrogation. So custodial means, arrest is the most the clearest example of a custodial situation. It's when you're in the custody of law enforcement. So arrest is definitely custodial. Putting handcuffs on you is almost certainly custodial because it's a hallmark of being arrested. If they tell you to stay in the car, you're not free to leave. That's likely custodial. If they tell you to sit down, sit on your hands, and don't move, that's probably custodial. Now, courts have found that when the police pull over a vehicle and talk to the person, ask them out of the vehicle, that is not custodial because theoretically they're free to leave whenever they want. So the question of whether or not someone is in custody for the purposes of Miranda is a case-by-case, fact-specific question. But basically what you're looking for is, would a reasonable person believe they're free to leave? So the question of whether or not it's custodial is a big one. We litigate that quite frequently. The second requirement is that it's an interrogation, meaning that law enforcement has to be asking you questions that are reasonably likely to produce an incriminating statement. So an example here is like, if the cops pull someone over, they cuff them, put them in the back of the car, and the person blurts out, I murdered my wife. That is not covered by Miranda because it's custodial, but it wasn't an interrogation. The person just voluntarily decided to, make that a very incriminating statement. So those are the two questions. It has to be both. It has to be custodial and it has to be an interrogation. Only then is Miranda triggered. Typical traffic stops, OWI, DUI arrests, those sorts of things. There's not even a situation where it's custodial until the person is cuffed and put in the back of the car. And all their incriminating statements were made before that. So with traffic stops, Miranda almost never comes into play. I did recently have a situation where someone got into a car accident. They were allegedly intoxicated. They walked off, and then they came back to the car accident, and then the police immediately cuffed them and started asking him questions about what happened. That is a traffic incident where they should have given them Miranda warnings, and they did not. So there are situations in traffic incidences where it comes up, but again, it requires an interrogation for them to be in custody and for them to make statements that are useful against them. I mean, if they were supposed to give someone Miranda warnings, but they had already admitted to the crime, then it only strikes the statements that were made after they were supposed to be given. So timing's a big issue. So basic takeaways for there are it has to be custodial and it has to be an interrogation. And if they weren't given in that situation, all you get is excluding whatever statements were made after they should have been given. Now, the big takeaway, I think, from Miranda is, you have the right to remain silent. You have the right to talk to an attorney. You should exercise your Miranda warnings before you're even given them. If you're ever talking with the police and you're not sure what they're talking to you about, or if you believe you might be the target of a criminal investigation, just say that you'd prefer not to speak with them and you'd prefer to speak with an attorney. That's the best advice. That's following Miranda before it's even given to you. But let me know in the comments if you have any further questions on this. I'd be happy to follow up.